Utah has a landlord-friendly breaking lease framework with a clear statutory provision addressing the landlord's duty to mitigate, making Utah more defined than some states that rely solely on common law. The governing law is found in the Utah Fit Premises Act, Utah Code, Title 57, Chapter 22, along with general landlord-tenant provisions in Title 57, Chapter 17, and contract law principles. If you're a landlord or tenant in Utah, the state provides a straightforward framework that balances the tenant's breach liability with the landlord's obligation to minimize damages. Let's start with the landlord's duty to mitigate damages. Utah has a statutory duty to mitigate established through case law and reinforced by the state's overall contract law framework. When a tenant breaks a lease and vacates, the landlord must make reasonable efforts to re-rent the unit. The landlord cannot simply collect rent from the departing tenant for the full remaining lease term without attempting to find a replacement. Utah courts have consistently upheld this mitigation requirement. The landlord must take reasonable steps, advertising the unit, showing it to prospective tenants, and accepting qualified applicants who meet the landlord's standard screening criteria. The landlord is not required to lower the rent below market rate or accept an unqualified tenant, but the landlord must treat the vacancy the same way they would treat any other vacancy in their portfolio. If the landlord re-rents the unit, the departing tenant's liability is limited to rent during the vacancy period plus reasonable re-rental costs, advertising, cleaning, minor repairs to return the unit to rentable condition. If the landlord fails to make reasonable efforts, the departing tenant can argue that the landlord's failure to mitigate should reduce their liability. Early termination clauses are generally enforceable in Utah. The state does not have a specific statute capping early termination fees, and Utah courts generally enforce reasonable contractual provisions. A clause requiring 30 to 60 days notice and a fee of 1 to 2 months' rent is typical and enforceable. Utah's contract law principles require that the fee represent a reasonable pre-estimate of damages rather than a penalty. But Utah courts tend to give reasonable deference to negotiated contract terms. Many Utah landlords include reletting fees in their leases, which cover the landlord's costs to re-rent the unit, including advertising, showing, and processing a new tenant's application. A reletting fee is distinct from an early termination fee. The reletting fee covers specific costs, while an early termination fee covers broader damages, including expected vacancy loss. Landlords should clearly define which fees apply and what they cover to avoid confusion and disputes. Military members have the right to break a lease under the Federal Service Members' Civil Relief Act. Active duty service members with qualifying orders, permanent change of station, deployment of 90 days or more, or orders to move into government housing, can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee, reletting fee, or penalty applies. Utah's military population is moderate, centered around Hill Air Force Base near Ogden, Dugway Proving Ground, and the Tooele Army Depot. Hill AFB is one of the largest Air Force installations in the country and generates regular SCRA lease terminations. Landlords in the Ogden, Layton, Clearfield, and Roy areas should have a standard process for handling military lease breaks. They're a regular part of operations in the Hill AFB rental corridor. Utah does not have a comprehensive state statute providing enhanced lease-breaking protections specifically for victims of domestic violence in the same detailed framework found in states like Washington or Virginia. However, Utah does have provisions that provide some protection. Under Utah's cohabitant abuse statutes and the general framework of protective orders, a tenant who obtains a protective order may have practical grounds to negotiate an early lease termination. Some Utah landlords voluntarily include domestic violence early termination clauses in their leases, allowing termination with 30 days' notice and a copy of a protective order or police report. While not required by state law, this practice is becoming more common and is considered a best practice by property management associations in the state. Tenants in Utah may break a lease if the landlord fails to maintain habitable conditions. Under the Utah Fit Premises Act, Section 57 to 22, 3 and following, the landlord has a duty to maintain the rental in a condition fit for human habitation. The Act specifies the landlord's obligations, including maintaining structural integrity, plumbing, heating, electrical systems, and compliance with building and health codes. If the landlord fails to maintain the property and the deficiency materially affects health and safety, the tenant can provide written notice to the landlord. The landlord then has a specific time frame to make repairs. The Act provides for different response times depending on the severity of the issue. If the landlord fails to act within the required time, the tenant has several remedies, including the right to terminate the lease. The tenant must follow the notice and cure process carefully, simply vacating without providing written notice and allowing the landlord time to repair undermines the tenant's position. The written notice should be specific, identifying the exact deficiencies and requesting repair within the statutory time frame. Utah also recognizes constructive eviction as grounds for lease termination. If the landlord's failure to maintain the property, or the landlord's affirmative actions, such as shutting off utilities or removing essential fixtures, makes the unit uninhabitable, the tenant can treat the lease as constructively terminated. The tenant must actually vacate within a reasonable time after the conditions arise. Continuing to occupy while claiming constructive eviction is inconsistent. Utah has a relatively fast eviction process, which indirectly affects breaking lease dynamics. Under Utah Code Section 78B6802, the landlord can file for eviction with just 3 days' notice for non-payment of rent. This fast timeline means that if a tenant stops paying rent as part of breaking the lease, the landlord can move quickly to regain possession and begin re-renting. The speed of the process reduces the landlord's vacancy exposure compared to states with longer eviction timelines. Utah also has a specific provision regarding abandonment. Under Section 78B6815, if a tenant abandons the property, leaves without notice, removes personal belongings, and stops paying rent, the landlord can retake possession after providing proper notice. The abandonment provisions give landlords a clear process for handling situations where a tenant simply disappears mid-lease without formal communication. From a practical standpoint, Utah has one of the fastest-growing rental markets in the country, which generally benefits tenants who break leases because landlords can re-rent quickly. Salt Lake City and the broader Wasatch Front, including Sandy, West Jordan, Murray, Draper, South Jordan, and Lehigh, have strong rental markets driven by technology, healthcare, financial services, and massive population growth from in-migration. When a tenant breaks a lease along the Wasatch Front, the landlord can typically re-rent within 2 to 4 weeks, and often faster in desirable locations. The departing tenant's financial exposure is usually limited. The Tech Corridor, sometimes called Silicon Slopes, running from Lehigh through Draper and into Salt Lake, has particularly strong demand. Companies like Adobe, Qualtrics, Pluralsight, and hundreds of startups create a deep pool of prospective tenants. Broken leases in this corridor typically result in minimal vacancy. Provo-Orem has a unique market driven by Brigham Young University and Utah Valley University. The student market operates on an academic calendar. Breaking a lease during the spring or summer when students are looking for fall housing means quick re-rental. Breaking mid-semester is harder. BYU's unique housing dynamics, including approved housing requirements, create a specific market segment that landlords must understand. Ogden has a moderate market influenced by Hill Air Force Base and Weber State University. Military lease breaks are common, and landlords near Hill AFB should have efficient SCRA processes. The base's regular personnel rotations create predictable lease break patterns. St. George in southern Utah has experienced explosive growth driven by retirees, remote workers, and the area's warm climate. The market has tightened significantly, and re-rental is generally quick. Park City has an extremely expensive resort market where workforce housing is scarce. A broken lease for workforce housing can often be filled immediately given the desperate demand. Logan, home to Utah State University, and Cedar City, home to Southern Utah University, have student-influenced markets with seasonal dynamics. One best practice for Utah landlords include both an early termination clause and a reletting fee provision in your lease, and clearly distinguish between them. The early termination clause allows the tenant to end the lease with defined notice and a known cost. The reletting fee covers your specific costs if the tenant breaks the lease without using the early termination provision. Having both tools gives you flexibility and gives the tenant a clear path for a planned early departure. Another best practice: begin re-rental efforts immediately when a tenant breaks the lease. Utah's strong market means you can minimize vacancy, but you need to act quickly and document your efforts. Keep records of listing dates, advertising platforms, inquiry counts, showing dates, and when you accepted a replacement tenant. This documentation establishes the departing tenant's actual liability and proves you mitigated. A third best practice: even though Utah doesn't require a specific domestic violence early termination provision, consider voluntarily including one in your lease. A clause allowing termination with 30 days' notice and a copy of a protective order or police report protects vulnerable tenants and reduces the risk of a tenant fleeing without notice because they felt they had no other option. Property management associations in Utah increasingly recommend this practice. Utah does not have a statutory cap on security deposits. The deposit amount is governed by the lease. The deposit must be returned within 30 days of the tenant vacating, along with an itemized statement of any deductions. If the landlord fails to comply, the landlord may be subject to liability. These rules apply whether the departure is a normal move-out or a broken lease. The 30-day timeline begins when the tenant vacates and returns the keys. For the complete guide to Utah breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.